go on the record in the matter 24 CF 155, State of Wisconsin versus Glen Wood. This date appears through District Attorney Kevin Schmidt in person. We have Mr. Wood in person with his counsel, Daniel Furcus. We're set today in this matter for a plea and sentencing. The 24 TR 688. We're set for a plea and sentencing in this case. Mr. Furcus, can you please recite the agreement that's been reached?
Your Honor, my client would be pleading guilty to count number 2 of operating a motor vehicle while under the influence. The third count would be dismissed or merged and dismissed. And I believe count 1 would be dismissed and read in. There'd be a joint recommendation for an IDIP guideline sentence.
Alrighty. And it's my understanding he has not sat 48 consecutive hours. Is that correct?
It was not consecutive hours. His time did cover 2 separate days. However, they were not 48 hours.
Okay. All right. And so I need to make sure that you understand, Mr. Wood, because I like to make sure that the defendants understand everything, that the law requires OWI thirds and higher to sit 48 consecutive hours. That means hour after hour for 48 hours before the court can grant any release on electronic monitor for house arrest or anything like that. And so do you understand that?
Yes, I do.
And it would be an immediate report. So after we're done here, you would immediately go to the jail, report, and sit 48 consecutive hours. And then if the court grants you the monitor, then you would be hooked up on that. Do you understand that?
Yes, I understand.
And do you wish to proceed with this plea and sentencing?
Yes, I do.
Okay. All right. So, Mr. Wood, I have in front of me this plea questionnaire waiver of rights form. Do you recognize this document?
Yes, I do.
Did your attorney go over this document with you thoroughly?
Yes.
And did he essentially go over it word for word?
Yep.
And so you understand everything correctly?
Yeah.
And did you sign that document?
Yes.
And there's an addendum to that plea questionnaire and waiver of rights. Did he go over that document with you?
Yes, ma'am.
And you understand it completely?
Yep.
And then is that your signature?
Yes, ma'am.
Okay. So it says that you're 65 years old. You have 14 years of schooling. You can read, write, you understand the English language. Is that correct?
Yes, ma'am.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Absolutely.
Did your attorney go over with you the mandatory minimums as well as the maximum possible penalties that you face?
Yes.
You are receiving treatment for mental illness or disorder, and you have had medications. Either of those interfere with your ability to comprehend or understand what's going on?
No.
And did you take your medications as prescribed?
Yes.
And so are you in a state right now where you fully understand and you can comprehend everything that is happening?
Oh, yeah.
Okay. Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page of the plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes, ma'am.
And you understand them completely?
Yep.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yeah.
Do you understand that here the state would have to prove for count 2, operating a motor vehicle while under the influence, a third offense, that on or around July 4th, 2024, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of a controlled substance? Do you understand what the state would have to prove?
Yes.
Do you understand that they would also show that this would be your third countable offense?
Yep.
Do you understand that upon conviction, you could be fined not less than $600 nor more than $2,000 and imprisoned for not less than 45 days, but no more than 1 year in the county jail?
Yes, ma'am.
You also understand that upon conviction, the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an AODA OWI assessment and follow through.
Yes, ma'am.
Now, do you also understand that with regards to this case, there is an agreement because you've completed the IDIP program. But you understand that the recommendation calls for the court to follow those guidelines. But the law states that if I think in my discretion, based upon facts and the circumstances, that a more harsher, stricter sentence should be applied. Do you understand? It's my discretion and I can do that.
Yep.
Do you understand? I could sentence you all the way to that maximum possible penalty if I thought it was warranted.
Yes, ma'am.
Do you still wish to proceed and enter a guilty
I
plea?
sure do.
Did you go over that criminal complaint with your attorney?
Yes.
In particular, that section where it's called the probable cause section, and it basically says what happened that day and why you were charged with these crimes?
Yes.
For the most part, are those facts accurate?
Absolutely.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of a controlled substance?
Yes, I am.
And this would be your third countable offense.
Yes, I am.
Mr. Firkus, may the court use the probable cause section of the criminal complaint to find a factual basis?
It's adequate, Your Honor.
Has anyone made any threats or any promises to you, Mr. Wood, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Absolutely.
and voluntarily?
Yep.
Has your attorney represented you competently?
Yes, he has.
Has he answered all of your questions?
Yes, he has.
Has he looked at this matter thoroughly?
Yes, he has.
And are you satisfied with his services?
Very much.
Do you have any questions for the court or for your attorney before I proceed?
No, I don't.
As to count 2, operating a motor vehicle while under the influence, third offense, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 2. The other counts in that case and the TR matter will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. We have the intoxicated driver intervention program to address and incentivize people to get treatment prior to entering pleas and to take steps that will be necessary to get their licenses after the conviction. So there's a good public interest for it. In this case, the defendant did that. They should have the reward for doing that. This is an RCS OWI. There was no alcohol and it was a low amount of THC. THC has lesser of an impact in driving than alcohol, so I think this should be followed. Thank you.
Thank you. Mr. Firkus.
Your Honor, we'd ask that you go along with what is a joint recommendation. I know you have to look at the seriousness of what occurred. It's OWI. Legislature's already told us how serious they take that by having mandatory minimums and things like that. I know you have to look at my client's character. His prior offense was from 2006, conviction of 2007. Pretty long gap between these. I know this happened in July of 2024, so we're a year and 4 months that he's been on bond, felony bond, no issue, no problems. He's completed all requirements of the IDAP program. I will not go into the details of that, Your Honor, as you are familiar with the program in your own county. And finally, you have to look at protecting the public. The sentence protects the public. It has consequences in addition to the immediate consequence of spending time in jail. He's going back to the jail today. And then to get his license back, he's had to do the assessment. He will have to have an ignition interlock device. All these things are kind of built into the sentence for protecting the public, Your Honor. Thank you.
Thank you. Mr. Wood, do you care to make any statement today? Let me know anything. You
Well,
don't have to.
I just want to say that I'm not thankful for what happened, but I'm thankful for the program and the counselors that helped me through this. I mean, I got a lot of medical issues and I thought I needed weed to suppress it because they wanted to put me on fentanyl patches and all kinds of other stuff for my illness. And I told them that marijuana was doing it right. And so I had edibles, and I've been doing edibles for 8 years. But I've been sober and not drugs for 9 years, a little over 9. And I'm glad that I got to take a look at this again and put me on the right track because I actually feel better right now.
I'm really glad to hear that.
Medically too. So,
It looks like you are. I remember when you first came in here to court, not that you looked bad by any means, and not that you looked grumpy, but you have a different disposition about you here today. And it looks more cheery and uplifting.
well, I'm just glad, you know, I was blessed by probably this thing too, to, you know, get back on track and stuff.
I'm sorry to hear about the pain that you suffer every day, having the chronic pain. That's not something that is easy to deal with and to handle. But it sounds like from what you've went through with the program and the counselors, you have a better way of combating that and fighting that, and it's put you in a better disposition.
Exactly, and I got a couple new sponsors out of it as far as I'm concerned.
And that's excellent. And I think this is your wife.
Yeah,
She's here and she's been here, I think, for every hearing with you. And so you have her support, and it's good to see. And am looking at her and her face and what she's feeling right now. And it looks like she probably has Glen back, a better Glen, because I'm not saying that you, again, were grumpy or anything previously, but you have this lighter feel about you here today.
thank you.
This is definitely a serious matter. Obviously, it's stated by both parties, and the legislature does tell us, with the high penalties and fines and fees, as well as a mandatory minimum with the OWI third and on. So it is serious. You've went through the program. You've learned a lot of things. You have a good character, and you are accepting the responsibility. You are being accountable, and you've learned a lot about yourself. You've done a lot of self-reflection about you personally, about your healing, about your pain, about everything in your life. And that's all positive, and you want to do better. And so that makes me feel better. I don't believe that you're a risk to the community, that you're going to do any harm. I think that this was something that happened. It may have happened for a reason, and the reason is to help and better you.
Absolutely.
And I'm very glad to see that. So there's no reason the court should stray from the IDIP guidelines and the recommendation. So what the court is going to do is, with the restricted controlled substance, $1,286 in fines and fees, plus a $10 blood draw, 45 days in jail, 24 months of revocation of your driver's license and ignition interlock device. Oh, I'm sorry, you're not it. She's not my OWI clerk, so it's a little bit,
Okay.
I need to go slower with her with the OWIs. And that's totally fine. I'm used to, but she's learning. It's all good.
Yeah.
So let me know if I need to repeat something. 45 days of jail, 24 months of the ignition interlock device, and revocation of your driver's license. When we're done here today, or once you're released from the 48-hour consecutive hours, you can report and go see Amy, our clerk out there, who's usually clerking these types of cases, and you can get a half-priced ignition interlock device form. Okay, so it's always good to have a half price, and if you have to have it, half price is good,
Yeah.
and it's a better insurance that you're going to go ahead and get that done.
All right.
So it also says 25 hours of community service. I don't know if you've done that extra time. I don't know if you want to do that extra time, but you do have the ability to convert that 25 hours of community service to additional jail days. So it would be 4 additional jail days. So it would cost an extra $100 to be on that monitor if you wish to bypass the community.
I've got
service.
9 hours and
You have how many?
9 so far.
9 so far. And so do you want to, I think there's a program requirement of 8. And then
I already did them.
Oh, you did. So you're on your way to getting 25.
Yeah.
Excellent. You just have to have them completed by the end of your sentence. All right. And so if you are going to be on monitor? And again, I see no reason why not to allow you to be on monitor. You're doing well, you're doing good, and you want to continue to do your community service. So I'm going to grant you the ability to be on that electronic monitor. It's house arrest, but it can be for Huber or community service. You can go to work, you can go to community service, You can go to doctor's appointments. You can go to AA. You can go
Oh,
to those
wow.
types of things. Okay?
Yeah.
Because those are all positive things I want you to continue to be a part of. Okay?
Thank you.
You can go to the grocery store one time a week, but you have your wife, so I don't know if that's a dual thing that you do, or if that's a her chore
my
versus
thing,
your
no.
chore type of thing. If there's something like, let's say, Thanksgiving dinner at the grandkids' house, that's something you won't be able to attend. But if it's something like somebody unexpectedly passes away and you have a funeral, all you need to do is talk to Miss Anderson and write a letter, and I will determine whether or not that's something that's approved or not approved. And again, that would determine the relationship and those types of things, because this is house arrest. You must prepay at 30 days ahead.
I already did.
Excellent. I'm glad to hear that. So everything seems to be good and seems to be in order. You have, I think it's $1,000 cash bond paid, and that goes and pays off most of your fines and fees. With the remaining fines and fees, I will accept a payment plan of $50 a month until paid off in full. Okay?
Okay.
So once you know how much you owe, just make sure you pay $50 a month. Failing to pay, the court would enter a civil judgment against you, or you could get a warrant and sit up to 6 months in jail. We don't want that. If you are having a significant and substantial financial hardship and you can't pay that for some reason, you have to write the court and we'll look at that and I'll review that, okay? 2 days jail credit, but not 48 consecutive hours. So when we're done here, you must go immediately report to jail, sit your 48 consecutive hours, and then Mr. Hatch and or Ms. Anderson will figure out who's going to come and put you on that monitor, okay? So you can be released. I would strongly encourage you stay away from any rubbing alcohol, any gasoline, anything that has alcohol like sanitizer. It could set the machine off. And then if it goes off and it says that you have a positive for alcohol, unfortunately, you're going to be told you're immediately revoked and you must go sit the remaining time in jail. No good time, no Huber. Okay? So
Okay.
very important you stay away from those types of things.
All right.
This stuff, don't touch that stuff.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail makes sure that they take that. In a case like this, you may be able to get it expunged through a written letter to the Department of Justice. It's easy to do. You can Google it, or you can ask Mr. Ferguson. He can assist you that way. Am I missing something, Mr. Schmidt?
Not for me.
Mr. Fergus?
No, Your Honor.
All right. Good luck, Mr. Wood.
Thank you, Your Honor.
I'm proud of you and I'm proud of where you are here today.
Thank you.
All right.